A lot of clients these days in the sexual harassment arena ask me, well, what do you think is going to happen if we go try my sexual harassment case, considering the environment we're in? And I thought a little bit, and then I answered this lady, and I said, well, this has been going on for some months now, and I'm not aware of any cases where people just walked into court and won the case because there's a Me Too movement going on. We still have to prove up the case. So how do you prove a case of sexual harassment is one of the questions sometimes people have. And I would like the clients to let me do that. I'd like to see what evidence is out there. Sometimes sexual harassment cases are proven simply on the credibility of the sexual harassment victim. Other times they may be proven by text messages. There may be company investigations where some people have been interviewed that admit some things were heard and witnessed. But the case needs to be proved. Just because we have an environment right now where I'm getting interviewed sometimes every day of the week about a sexual harassment case, and you're hearing about a lot of people coming out and talking about sexual harassment against all kinds of famous people, I'm not sure that's really changed anything in the court system. The sexual harassment has to be severe and pervasive. If it is a one-time act, it is not likely to be sexual harassment. If somebody asks someone out on a date once, they say, no, I'm not interested, they never say it again, it's not a case. The other thing with sexual harassment is it does have to be unwelcome, and the person doing the stuff needs to know it's unwelcome. If the harasser doesn't know, then who knows what's going on in his mind. So it's important that the victims say, I'm not interested in that kind of relationship with you. Please stop asking me out. I only want to be involved in an employment relationship with you where you're my supervisor or coworker or whatever it is. And it has to be offensive. If the conduct is every day the guy says, I like your green sweater, or I like that dress you're wearing, it may or may not be offensive. If they start talking about the way the dress looks on someone, describing body parts, that's getting more offensive. So we have to, as attorneys, examine the actual conduct, whether it's verbal, whether it's physical, whether it's a text message. A lot of cases now involve text messages of sexual harassment. And we need to see if this is going to be offensive to a reasonable man or woman who is about the same age and about the same educational level as the victim. And what may be offensive to somebody that's 20 years old may be different than what's offensive to somebody who's 65. So that's the first two things. It needs to be offensive. It needs to be unwelcome. The conduct needs to happen from a supervisor, manager, or owner for the company to be strictly liable, which means the company is responsible without somebody complaining about the harasser first. If the conduct is by a coworker who doesn't have any power over the employee, not even a lead or anything like that, the company is responsible for that conduct after the victim has complained and it's continued. So sexual harassment involves harassment, conduct being done, verbal, physical, and it may also involve retaliation. Most of the time, though, the retaliation needs to be quite severe. It really needs to be a job termination. Somebody having a job at a different facility a couple miles away, not 50 or 60, with about the same shift, the same pay, the court is not going to find that retaliation. I had a case that we won on a lot of things, but we did not win on retaliation when a lady who worked in a fast food restaurant, after she complained of the harassment, had to go in the back parking lot and sweep. And I think she also had to clean the bathrooms, but that was something probably she already did. So the retaliation needs to be severe. It needs to really involve a job termination for it to be serious. So you have harassment. You also have situations where people are fired. You may also have situations where it's a coworker that complains about the harassment. Maybe the manager gets fired. Maybe someone else in the company was friends with the manager, and that coworker gets fired for complaining, or the coworker has to show up to a deposition and testify, and they say, yes, there were some events I saw, and yes, it was what she's describing or he's describing. And at that point, the company gets very angry that that has gone on record under oath, and they fire the person. So there are several situations with sexual harassment in the workplace I've told you about. There are also situations where customers sexually harass people. I had a very large case, and it was a female who was harassed by a series of customers at the store. And the depositions and discovery of the case, I realized this retail establishment was only hiring women that looked like models, and they were hoping they flirted with the customers. And that was not something she wanted to do. And it was a very large store, 50,000, 100,000 square feet, something like that. And you know, working late at night, she's being cornered by these really creepy people who have come in. At a certain point, she has an emotional breakdown and quits. So we got them big time for customer harassment on that case. So customer harassment is something the employer is responsible for if the employer knows about it and they don't fix it, and it keeps going on. If you have any questions about sexual harassment, man versus man, woman versus woman, I've dealt with every scenario there is with sexual harassment, and the attorneys who work for me also have had many sexual harassment cases. We've won in trial, we've won in arbitration, we've won appeals. So it's something that we do have particular knowledge of. We'd like to hear from you. 877-525-0700. We have offices all over California. Please give us a call.